Question 1. The monitoring system demonstrates an unusual trading pattern by a senior executive at TechnoPro Holdings, involving a significant purchase of shares in a competitor company shortly before a major, non-public announcement by that competitor. What is the most appropriate immediate next step for TechnoPro Holdings Compliance Department? Option A. Immediately report the trading activity to the Financial Conduct Authority, FCA, as a potential instance of insider dealing. Option B. Initiate a thorough internal investigation into the trading activity, gathering all relevant information and cross-referencing it with the executive's access to non-public information and the competitor's announcement timeline, in accordance with FCA Market Abuse Regulation, MAR guidelines. Option C. Dismiss the alert as likely coincidental, given the executive's seniority and presumed knowledge of legitimate market factors. Option D. Discuss the trading activity directly with the senior executive to understand their rationale before any formal investigation. Correct answer is B. Initiate a thorough internal investigation into the trading activity, gathering all relevant information and cross-referencing it with the executive's access to non-public information and the competitor's announcement timeline, in accordance with FCA Market Abuse Regulation, MAR guidelines. Explanation. This scenario presents a professional challenge because TechnoPro Holdings, as a regulated entity, must ensure its internal systems and employee conduct align with the stringent requirements of the Financial Conduct Authority, FCA Handbook, specifically regarding market abuse and insider dealing. The monitoring system's alert requires immediate and accurate interpretation to prevent potential regulatory breaches. The challenge lies in distinguishing between legitimate market activity and potential misconduct, necessitating a thorough understanding of the relevant FCA rules and TechnoPro's own internal policies. Careful judgment is required to avoid both overreacting to benign events and underreacting to genuine risks. The correct approach involves a systematic review of the alert against the definition of inside information and the prohibition of insider dealing as outlined in the FCA's Market Abuse Regulation, MAR, and relevant sections of the Conduct of Business Sourcebook, COBS. This approach prioritizes gathering all necessary facts, consulting internal compliance procedures, and escalating appropriately if a potential breach is identified. This aligns with the FCA's expectation that firms have robust systems and controls to detect and prevent market abuse. Specifically, MAR Article 7 defines inside information, and MAR Article 14 prohibits its unlawful disclosure and insider dealing. TechnoPro's compliance department is responsible for investigating such alerts in accordance with these regulations and the firm's own policies, which are designed to implement these regulatory requirements. An incorrect approach of immediately reporting the alert to the FCA without internal investigation would be premature and potentially damaging to the individual's reputation and TechnoPro's operational efficiency. It fails to acknowledge the firm's responsibility to conduct its own due diligence and could be seen as an abdication of responsibility. Another incorrect approach of dismissing the alert without a proper review, based solely on the employee's seniority, ignores the fundamental principle that all alerts must be investigated regardless of the individual involved. This demonstrates a failure to adhere to the principle of treating all potential market abuse equally, and could lead to significant regulatory sanctions if an actual breach is overlooked. Furthermore, an approach that involves discussing the alert with the employee before any internal investigation is completed would constitute a breach of confidentiality and could tip off the individual, hindering any subsequent investigation and potentially violating MAR Article 11 regarding market soundings. The professional decision-making process for similar situations should involve a clear documented procedure for handling suspicious activity alerts. This process should include 1. Immediate acknowledgement and logging of the alert. 2. A thorough, fact-based investigation by the compliance team, referencing relevant regulatory rules and internal policies. 3. Consultation with legal counsel if necessary. 4. Appropriate escalation based on the findings. And 5. Timely and accurate reporting to the regulator only when a breach is confirmed and all internal processes have been exhausted. This structured approach ensures regulatory compliance, protects the firm and its employees, and upholds market integrity. Question 2. The monitoring system demonstrates a pattern of trading activity by a TechnoPro Holdings employee that, based on its algorithms exhibits characteristics consistent with potential insider dealing. The employee has recently been involved in discussions related to a significant upcoming corporate announcement. What is the most appropriate immediate next step for TechnoPro Holdings Compliance Department? Option A. Immediately dismiss the trading alert as a false positive, assuming the employee is acting legitimately. Option B. Initiate a formal internal investigation into the employee's trading activity and related communications, following established company policy and FCA guidelines. Option C. Report the flagged activity directly to the Financial Conduct Authority without conducting any internal review. Option D. Confront the employee directly with the alert and demand an explanation before any investigation. The correct answer is B. Initiate a formal internal investigation into the employee's trading activity and related communications, following established company policy and FCA guidelines. Explanation. This scenario presents a professional challenge because TechnoPro Holdings, as a regulated entity, must ensure its internal systems and employee conduct align with the stringent requirements of the Financial Conduct Authority (FCA) handbook, specifically concerning market abuse and insider dealing. The monitoring system flagging potential activity requires a nuanced response that balances the need for thorough investigation with the protection of individual rights and the avoidance of premature accusations. Careful judgment is required to determine the appropriate next steps without compromising regulatory obligations or employee trust. The correct approach involves initiating a formal internal investigation in accordance with TechnoPro Holdings' established policies and FCA guidelines. This approach is professionally sound because it directly addresses the potential regulatory breach by gathering facts, assessing evidence, and determining if a contravention of the Market Abuse Regulation (MAR) has occurred. This systematic process ensures that any action taken is based on evidence and is compliant with the FCA's expectations for firms to have robust systems and controls to prevent and detect market abuse. It upholds the principle of treating customers and market participants fairly and maintaining market integrity. An incorrect approach would be to immediately dismiss the alert without further inquiry. This fails to meet TechnoPro Holdings' regulatory obligation under MAR to have adequate arrangements to prevent and detect market abuse. It could lead to a failure to identify and report actual instances of insider dealing or market manipulation, exposing the firm to significant regulatory sanctions. Another incorrect approach would be to confront the employee directly based solely on the monitoring system's flag, without conducting a proper investigation. This could lead to an unfair accusation, damage employee relations, and potentially prejudice any subsequent formal investigation. It also bypasses the necessary due diligence required by regulatory frameworks to establish facts before taking disciplinary or reporting actions. A further incorrect approach would be to escalate the matter to the FCA without first conducting a thorough internal review. While reporting is crucial, firms are expected to undertake their own investigations to ascertain the facts and determine the appropriate course of action, which may include self-reporting if a breach is confirmed. Premature reporting without internal due diligence can be inefficient and may not provide the FCA with the necessary information for an informed assessment. The professional decision-making process for similar situations should involve a structured approach. 1. Acknowledge and document the alert from the monitoring system. 2. Consult TechnoPro Holdings' internal policies and procedures for handling such alerts. 3. Initiate a preliminary review to assess the severity and nature of the flagged activity. 4. If the preliminary review indicates a potential regulatory breach, commence a formal internal investigation, ensuring it is conducted by appropriately trained personnel. 5. Gather all relevant evidence, including communications, trading records, and any other pertinent information. 6. Analyze the evidence against the relevant provisions of the FCA handbook, particularly MAR. 7. Based on the findings, determine the appropriate course of action, which may include disciplinary measures, reporting to the FCA, or closing the matter if no breach is found. 8. Maintain comprehensive records of the entire process. Question 3. System analysis indicates that a senior analyst at TechnoPro Holdings has observed a client engaging in trading patterns that appear to be designed to manipulate market prices, specifically by placing a series of large buy orders just before the market opens, and then canceling them shortly after, a practice known as layering. The analyst is concerned this behavior may constitute market abuse under the UK's Market Abuse Regulation (MAR), What is the most appropriate immediate course of action for the analyst to take? Option A. Directly contact the client to inquire about their trading strategy and explain why their current approach might be problematic. Option B. Discuss the observed trading patterns with other analysts in the team to gather their opinions on whether it constitutes market abuse. Option C. Immediately report the observed trading patterns to the TechnoPro Holdings Compliance Department and the Money Laundering Reporting Officer, MLRO. Option D. Ignore the trading patterns, assuming the client is experienced and likely aware of any regulatory implications. The correct answer is C. Immediately report the observed trading patterns to the TechnoPro Holdings Compliance Department and the Money Laundering Reporting Officer, MLRO. Explanation. This scenario presents a professional challenge for TechnoPro Holdings employees due to the inherent conflict between client confidentiality and the need to report potential regulatory breaches. Navigating this requires a deep understanding of the applicable regulatory framework, specifically the Financial Conduct Authority, FCA, handbook, and relevant UK legislation governing financial services. The core tension lies in balancing the duty of confidentiality owed to clients with the statutory and regulatory obligations to report suspicious activities that could indicate market abuse or other financial crimes. TechnoPro Holdings, as a regulated entity, has a responsibility to foster a culture of compliance and ensure its employees are equipped to identify and escalate such concerns appropriately. The correct approach involves a structured escalation process that prioritizes regulatory compliance and client protection. This means immediately reporting the observed behavior to the designated compliance officer, or MLRO, Money Laundering Reporting Officer, within TechnoPro Holdings, without directly confronting the client or making independent judgments about the legality of their actions. This ensures that the matter is handled by individuals with the expertise and authority to investigate, liaise with regulators if necessary, and take appropriate action, thereby upholding TechnoPro Holdings' regulatory obligations and preventing potential harm to the market or other investors. An incorrect approach would be to ignore the behavior, assuming it is not significant or within acceptable bounds. This failure directly contravenes the FCA's principles for businesses, particularly Principle 11, Relations with Regulators, which requires firms to be open and cooperative with the FCA. It also risks enabling market abuse or other illicit activities, leading to severe regulatory sanctions, reputational damage, and potential criminal liability for both the individual and the firm. Another incorrect approach is to directly confront the client about the suspected illicit activity. While seemingly proactive, this bypasses the established internal reporting mechanisms and could alert the client to an ongoing investigation, potentially leading to the destruction of evidence or further attempts to conceal the activity. This action could also jeopardize any subsequent regulatory investigation and expose TechnoPro Holdings to accusations of obstructing justice or failing to manage risk effectively. Furthermore, it places the employee in a position of making judgments beyond their remit, potentially misinterpreting the situation and acting without proper authority. A third incorrect approach would be to discuss the suspected activity with colleagues who are not involved in compliance or risk management. This constitutes a breach of confidentiality and could lead to the dissemination of sensitive information, creating unnecessary alarm or speculation within the firm. It also undermines the integrity of the internal reporting process and could be construed as an attempt to circumvent proper channels, again exposing TechnoPro Holdings to regulatory scrutiny. The professional decision-making process in such situations should involve a clear understanding of internal policies and procedures for reporting suspicious activity. Professionals should be trained to recognize red flags and to escalate concerns promptly to the appropriate internal function, e.g., compliance, MLRO. They must then trust and follow the established escalation and investigation protocols, avoiding independent action that could compromise the process or violate regulatory requirements. The paramount consideration is always adherence to the regulatory framework and the firm's compliance obligations. Question 4. Benchmark analysis indicates that a TechnoPro Holdings employee has observed a pattern of transactions that, while not explicitly illegal on their face, appear to circumvent certain reporting thresholds designed to prevent illicit financial activities. The employee is concerned that these transactions, if aggregated, could indicate a deliberate attempt to avoid regulatory scrutiny. The employee has a duty of confidentiality to the client involved. What is the most appropriate course of action for the TechnoPro Holdings employee in this situation? Option A. Advise the client that their transaction patterns are raising concerns and suggest they adjust their activities to avoid regulatory attention. Option B. Discreetly escalate the concern through TechnoPro Holdings' internal compliance reporting channels without directly confronting the client or disclosing specific confidential details to unauthorized internal personnel. Option C. Immediately report the observed transaction pattern to the relevant regulatory authority, providing all details of the client and the transactions. Option D. Discuss the observed transaction pattern with a trusted colleague in another department to get their opinion on the matter. Correct answer is C. Immediately report the observed transaction pattern to the relevant regulatory authority, providing all details of the client and the transactions. Explanation. This scenario presents a professional challenge for a TechnoPro Holdings employee due to the inherent conflict between client confidentiality and the obligation to report potential regulatory breaches. The employee must navigate the delicate balance of protecting sensitive client information while upholding their duty to the regulatory framework governing TechnoPro Holdings operations. Careful judgment is required to avoid both breaching confidentiality and failing to report a potential violation, either of which could have severe professional and legal consequences. The correct approach involves discreetly escalating the concern through appropriate internal channels, such as the compliance department or a designated reporting officer, without directly confronting the client or disclosing specific confidential details to unauthorized parties. This aligns with regulatory requirements that mandate reporting of suspicious activities or potential breaches of financial regulations. By utilizing internal reporting mechanisms, the employee fulfills their obligation to alert the relevant authorities within TechnoPro Holdings, allowing the company to conduct a proper investigation and take necessary action, thereby protecting both the client and the firm from further harm or regulatory penalties. This method respects client confidentiality while ensuring compliance with the law. An incorrect approach would be to directly confront the client about the suspected breach. This could lead to the client taking steps to conceal the activity, destroying evidence, or even retaliating against the employee, thereby hindering any potential investigation and exacerbating the regulatory issue. It also risks breaching client confidentiality by discussing sensitive matters outside of authorized channels. Another incorrect approach is to ignore the suspicion and take no action. This constitutes a failure to report a potential regulatory breach, which is a direct violation of regulatory obligations. Such inaction could expose TechnoPro Holdings to significant fines, sanctions, and reputational damage, and the employee could face disciplinary action, including termination and potential personal liability. A further incorrect approach would be to discuss the suspicion with colleagues who are not involved in compliance or oversight. This constitutes a breach of client confidentiality and could lead to the spread of unsubstantiated rumors, damaging both the client's reputation and the internal working environment at TechnoPro Holdings. It also bypasses the established protocols for reporting regulatory concerns. Professionals should employ a decision-making framework that prioritizes adherence to the regulatory framework and ethical guidelines. This involves first identifying the potential issue, then assessing its severity and the applicable regulations. The next step is to consult internal policies and procedures for reporting such concerns. If a clear reporting channel exists, it should be utilized. If unsure, seeking guidance from the compliance department or a supervisor is crucial. The overriding principle is to act responsibly and ethically, ensuring that all actions are taken within the bounds of the law and company policy, while respecting confidentiality where appropriate. Question 5. The monitoring system demonstrates an unusual pattern of access to client financial records within TechnoPro Holdings' secure database, raising a potential concern regarding data privacy compliance. What is the most appropriate initial step for the compliance officer to take? Option A. Assume the alert is a false positive due to system glitches and disregard the flagged activity. Option B. Contact the individuals whose access is flagged and directly question them about their actions without prior internal review. Option C. Immediately report the flagged activity to the relevant regulatory authority, citing a potential breach of client data privacy. Option D. Initiate a detailed internal investigation to understand the nature, scope, and context of the access pattern, cross-referencing with TechnoPro Holdings' data handling policies and applicable regulations. The correct answer is C. Immediately report the flagged activity to the relevant regulatory authority, citing a potential breach of client data privacy. Explanation: this scenario presents a professional challenge because TechnoPro Holdings' internal monitoring system has flagged a potential breach of regulatory compliance related to client data handling. The challenge lies in interpreting the flagged activity, determining its severity, and deciding on the appropriate course of action without causing undue alarm or overlooking a genuine violation. The need for careful judgment stems from the potential for significant reputational damage, regulatory penalties, and loss of client trust if the situation is mishandled. The correct approach involves a thorough, fact-based investigation to ascertain the nature and extent of the flagged activity. This requires consulting the relevant TechnoPro Holdings' internal policies and the specific regulatory framework governing data protection within the exam's jurisdiction. The professional justification for this approach is rooted in the principle of due diligence and the obligation to comply with all applicable laws and regulations. Specifically, it aligns with the regulatory requirement to maintain robust data protection measures and to investigate any suspected breaches promptly and thoroughly. This ensures that any actual noncompliance is identified, addressed, and rectified in accordance with legal and ethical standards, thereby protecting both the company and its clients. An incorrect approach would be to immediately escalate the flagged activity to senior management or regulatory bodies, without conducting an initial internal review. This is a regulatory failure because it bypasses the established internal procedures for handling such alerts and could lead to unnecessary panic or premature reporting of a non-issue. Ethically, it demonstrates a lack of independent judgment and an abdication of responsibility to first understand the situation. Another incorrect approach would be to dismiss the flagged activity as a system error without any corroborating evidence or investigation. This is a significant regulatory failure, as it neglects the potential for a genuine data breach or compliance violation. Ethically, it represents a dereliction of duty to protect client data and uphold regulatory standards, potentially exposing TechnoPro Holdings to severe penalties and reputational harm. A further incorrect approach would be to attempt to manually alter or delete the flagged data to conceal the activity. This is a severe regulatory and ethical failure, constituting obstruction of a compliance investigation and potentially falsifying records. It directly violates principles of transparency, accountability, and lawful data handling. The professional decision-making process for similar situations should involve a structured multi-stage approach. 1. Acknowledge and document the alert. 2. Consult internal policies and relevant regulations. 3. Conduct a preliminary objective investigation to gather facts. 4. Based on findings, determine the appropriate escalation path, which may include further investigation, reporting to internal compliance, or external regulatory notification. 5. Maintain clear and accurate records of all actions taken. Question 6. Upon reviewing a new client onboarding at TechnoPro Holdings, a senior analyst notes that the client's stated investment objective appears to involve strategies that could potentially skirt the edges of market manipulation regulations as defined by the FCA handbook. The client has explicitly requested a portfolio construction that prioritizes aggressive short-term gains through complex derivative strategies, with a stated disregard for the long-term sustainability of the positions if they can be unwound profitably quickly. The analyst is concerned that, while not explicitly illegal on the face of it, the approach could be interpreted as manipulative under certain market conditions and may violate the spirit of the FCA's principles for businesses. What is the most appropriate course of action for the senior analyst at TechnoPro Holdings? Option A. Immediately refuse to onboard the client, citing potential regulatory concerns without further investigation or discussion. Option B. Engage in a detailed discussion with the client to understand the rationale behind their aggressive strategy, explain the potential regulatory implications and FCA principles that might be engaged, and explore alternative compliance strategies that could achieve similar objectives. Option C. Advise the client on how to structure their requests and trades to ensure they remain technically within the letter of the law, even if it means pushing the boundaries of regulatory intent. Option D. Proceed with the client's requested portfolio construction, assuming the client is aware of the risks and that the strategies are not explicitly prohibited by law. The correct answer is D. Proceed with the client's requested portfolio construction, assuming the client is aware of the risks and that the strategies are not explicitly prohibited by law. Explanation. This scenario presents a professional challenge due to the inherent conflict between a client's stated wishes and the potential for those wishes to lead to regulatory noncompliance or ethical breaches. TechnoPro Holdings, as a regulated entity, must prioritize adherence to the specified regulatory framework, which in this case is assumed to be the UK's Financial Conduct Authority, FCA, Handbook and Relevant CISI, Chartered Institute for Securities and Investment, Professional Practice Guidelines. The core of the challenge lies in balancing client service with the duty to uphold regulatory integrity and professional standards. The correct approach involves a thorough understanding of the client's request, a clear identification of any potential regulatory conflicts, and a proactive, transparent communication strategy with the client. This approach prioritizes regulatory compliance by seeking clarification and offering compliant alternatives, thereby safeguarding both the client and TechnoPro Holdings from potential penalties and reputational damage. It aligns with FCA principles such as acting with integrity, due skill, care and diligence, and maintaining adequate controls. CISI guidelines also emphasize honesty, integrity, and acting in the best interests of clients within the bounds of the law and regulations. An incorrect approach would be to proceed with the client's request without fully investigating its regulatory implications. This could lead to breaches of FCA rules, such as those related to market abuse, insider dealing, or misleading statements, depending on the specifics of the request. Ethically, it would demonstrate a failure to act with due skill, care, and diligence, and potentially a lack of integrity. Another incorrect approach would be to dismiss the client's request outright without attempting to understand the underlying intent or offering compliant solutions. This could be seen as poor client service and a failure to explore all avenues to meet client needs within regulatory boundaries. Finally, attempting to circumvent regulations to fulfill the client's request, even with the client's consent, is a severe regulatory and ethical failure, exposing both parties to significant risk. Professionals should adopt a decision-making framework that begins with a comprehensive understanding of the client's objective. This should be followed by a rigorous assessment against the applicable regulatory framework, FCA Handbook, CISI guidelines. If a conflict is identified, the next step is to engage in open and honest dialogue with the client, explaining the regulatory constraints and proposing compliant alternatives that achieve a similar outcome. Documentation of all discussions and decisions is crucial for demonstrating due diligence and compliance. Question 7. The risk matrix shows a pattern of unusual transaction activity within TechnoPro Holdings' wealth management division that, if confirmed, could indicate a breach of anti-money laundering regulations. The compliance officer has flagged this as a high-priority concern requiring immediate attention. TechnoPro Holdings must decide on the most appropriate course of action. Option A. Initiate a comprehensive internal investigation to gather all relevant facts and evidence regarding the flagged transactions, consult with legal and compliance, and then determine the appropriate reporting obligations. Option B. Dismiss the flagged transactions as minor anomalies and continue with normal business operations without further investigation. Option C. Immediately report the suspicion of potential anti-money laundering breaches to the relevant regulatory authority without further internal inquiry. Option D. Advise the client associated with the unusual transactions to self-correct the activity before any external reporting is considered. The correct answer is A. Initiate a comprehensive internal investigation to gather all relevant facts and evidence regarding the flagged transactions, consult with legal and compliance, and then determine the appropriate reporting obligations. Explanation. This scenario presents a professional challenge for TechnoPro Holdings due to the inherent conflict between client confidentiality and the need to report potential regulatory breaches. The firm must navigate the delicate balance of upholding its duty to its clients while adhering to its legal and ethical obligations to the relevant regulatory bodies. Careful judgment is required to ensure that TechnoPro Holdings acts with integrity and avoids any actions that could be construed as complicity or negligence. The correct approach involves a thorough internal investigation to gather all pertinent facts before making a decision on reporting. This allows TechnoPro Holdings to understand the scope and materiality of the potential breach and to take appropriate remedial actions internally if necessary. This approach is professionally sound because it prioritizes due diligence and factual accuracy. It aligns with regulatory expectations that firms should proactively identify and address compliance issues. By investigating internally first, TechnoPro Holdings can present a comprehensive and well-supported report to the regulator, demonstrating its commitment to compliance and its ability to manage risk effectively. This also allows for the possibility of self-reporting with a clear understanding of the situation, which is often viewed favorably by regulators. An incorrect approach would be to immediately report the suspicion to the regulator without conducting an internal investigation. This could lead to an unfounded report, damaging the client relationship and potentially triggering an unnecessary regulatory inquiry. It fails to demonstrate due diligence and a responsible approach to risk management. Another incorrect approach would be to ignore the red flags identified in the risk matrix and take no action. This would be a clear violation of regulatory obligations and ethical standards. TechnoPro Holdings would be failing in its duty to supervise its employees and to ensure compliance with applicable laws and regulations, potentially exposing itself and its employees to significant penalties. A further incorrect approach would be to discuss the potential breach with the client and ask them to rectify the situation before reporting. While seemingly client-friendly, this could be interpreted as an attempt to conceal a regulatory breach or to allow the client to avoid accountability, which is ethically and regulatorily unacceptable. It undermines the integrity of the reporting process and could be seen as obstruction. The professional decision-making process for similar situations should involve a structured approach. First, acknowledge and document the identified risk. Second, initiate an internal fact-finding investigation to understand the nature, extent, and potential impact of the issue. Third, consult with internal legal and compliance departments to assess the regulatory implications. Fourth, based on the findings, determine the appropriate course of action, which may include internal remediation, reporting to the regulator, or a combination of both. Throughout this process, maintaining objectivity and a commitment to regulatory compliance are paramount. Question 8. The monitoring system demonstrates a pattern of client communication logs within TechnoPro Holdings that deviates from the standard archiving protocol, specifically regarding the timestamp accuracy of certain outgoing electronic messages. This deviation has been flagged for potential non-compliance with record-keeping regulations. TechnoPro Holdings Head of Compliance must decide how to proceed. Option A. Initiate a comprehensive internal investigation by the Compliance Department to review the flagged logs, cross-reference them with other available data, and determine the root cause and extent of the deviation, documenting all findings and proposed actions. Option B. Instruct the relevant personnel to permanently delete the flagged communication logs to avoid any potential regulatory scrutiny. Option C. Immediately instruct the IT department to correct the timestamps in the flagged communication logs to align with the standard archiving protocol, assuming a minor system glitch. Option D. Forward the flagged communication logs directly to the relevant regulatory authority with a note indicating a potential record-keeping anomaly. The correct answer is A. Initiate a comprehensive internal investigation by the Compliance Department to review the flagged logs, cross-reference them with other available data, and determine the root cause and extent of the deviation, documenting all findings and proposed actions. Explanation. This scenario presents a professional challenge because TechnoPro Holdings' internal monitoring system has flagged a potential breach of regulatory guidelines concerning client communication logs. The challenge lies in interpreting the flagged activity, determining its severity, and deciding on the appropriate course of action without compromising regulatory compliance or client confidentiality. The need for careful judgment stems from the potential for both minor procedural oversights and significant compliance failures, each requiring a distinct response. The correct approach involves a thorough, documented investigation of the flagged communication logs by the Compliance Department, adhering strictly to TechnoPro Holdings' internal policies and relevant regulatory frameworks. This approach is professionally sound because it prioritizes a systematic and evidence-based assessment. It ensures that any potential breach is identified, understood, and addressed in accordance with established procedures and legal obligations. This methodical process safeguards TechnoPro Holdings from regulatory penalties, reputational damage, and ensures the integrity of its client dealings. The regulatory justification lies in the principle of maintaining accurate and complete records, as mandated by financial services regulations, and the ethical obligation to act with due diligence and transparency. An incorrect approach would be to dismiss the flag without a proper investigation, assuming it is a system error. This fails to uphold the duty of care and due diligence required by regulatory bodies. It risks overlooking a genuine compliance issue, which could lead to severe penalties, loss of licenses, and damage to client trust. Ethically, it demonstrates a lack of commitment to regulatory adherence and client protection. Another incorrect approach would be to immediately report the flagged activity to external regulators without conducting an internal investigation first. While transparency is important, premature external reporting without a clear understanding of the situation can be counterproductive. It may create unnecessary alarm, damage TechnoPro Holdings' reputation, and could be seen as an overreaction if the issue is minor or a misunderstanding. Regulatory bodies expect firms to have robust internal control mechanisms and to attempt to resolve issues internally before escalating, unless the issue is of a critical and immediate nature. A third incorrect approach would be to delete or alter the flagged communication logs to remove the perceived issue. This is a severe ethical and regulatory violation, constituting obstruction of justice and a deliberate attempt to conceal non-compliance. Such an action would have dire consequences, including significant fines, criminal charges, and permanent disqualification from the industry. The professional decision-making process for similar situations should involve a structured approach. First, acknowledge and document the alert. Second, initiate an internal investigation following established protocols. Third, gather all relevant evidence. Fourth, assess the findings against regulatory requirements and company policies. Fifth, determine the appropriate remediation steps, which may include internal disciplinary action, client notification, or reporting to regulators. And finally, document the entire process and outcome. Question 9. Examination of the data shows that a senior analyst at TechnoPro Holdings, who has recently been privy to confidential merger discussions, has made a series of unusually large and speculative trades in the stock of the target company just prior to a public announcement. Option A. Ignore the trading activity, assuming it is coincidental and not related to the confidential information. Option B. Immediately report the suspicious trading activity to the TechnoPro Holdings Compliance Department for a formal internal investigation. Option C. Publicly disclose the suspicious trading activity to the market to ensure transparency. Option D. Confront the senior analyst directly about the trades and the confidential information. The correct answer is B. Immediately report the suspicious trading activity to the TechnoPro Holdings Compliance Department for a formal internal investigation. Explanation. This scenario presents a professional challenge for TechnoPro Holdings due to the potential for conflicts of interest and the need to maintain client confidentiality and market integrity. The data suggests an internal employee may possess material non-public information that could unfairly influence investment decisions. Navigating this requires strict adherence to regulatory frameworks designed to prevent insider trading and ensure fair markets. The core of the challenge lies in balancing the need to investigate potential misconduct with the rights of the employee and the company's operational continuity. The correct approach involves a structured, confidential internal investigation that prioritizes regulatory compliance and ethical conduct. This means immediately reporting the suspicion to the relevant compliance officer or legal department within TechnoPro Holdings, who will then initiate a formal, discreet inquiry. This inquiry must be conducted in accordance with the company's internal policies and relevant securities regulations, which typically mandate prompt reporting of suspicious activity and prohibit the misuse of material non-public information. The goal is to gather facts without prejudicing the employee or tipping off others, and to determine if a breach of regulations has occurred. This approach upholds the principles of market fairness, investor protection, and corporate governance. An incorrect approach would be to ignore the data, assuming it is unsubstantiated or not significant enough to warrant action. This failure to investigate potential insider trading exposes TechnoPro Holdings to severe regulatory penalties, reputational damage, and legal liabilities. It also undermines the ethical foundation of the firm and erodes trust among investors and stakeholders. Another incorrect approach is to confront the employee directly without involving the compliance or legal departments. This can lead to the destruction of evidence, alert the employee to the investigation prematurely, and potentially create legal complications for the company, such as claims of wrongful termination or defamation if the accusation is unfounded or mishandled. It bypasses established procedures designed to ensure a fair and thorough investigation. A third incorrect approach is to immediately report the suspicion to external regulatory bodies without conducting an initial internal assessment. While reporting is crucial, a preliminary internal review helps to ascertain the validity of the suspicion and gather initial facts, which can streamline the external reporting process and ensure that regulatory bodies are provided with well-founded concerns. Acting solely on suspicion without any internal due diligence might be seen as an overreaction and could strain resources unnecessarily. The professional decision-making process for similar situations should involve a clear understanding of the company's internal whistleblowing and compliance policies, as well as relevant securities laws. When suspicious activity is identified, the immediate step is to escalate the concern through the designated internal channels, typically the compliance or legal department. This ensures that the matter is handled by trained professionals who understand the legal and ethical implications. The investigation should be conducted with utmost discretion and in a manner that preserves evidence and respects the rights of all parties involved, while always keeping regulatory obligations at the forefront. Question 10. Assessment of how a TechnoPro Holdings analyst privy to confidential information about an impending hostile takeover bid for a publicly traded technology firm should ethically and legally respond to this knowledge, considering the potential for significant market impact. Option A. Inform a close friend who is an avid investor about the upcoming bid, suggesting they consider investing. Option B. Immediately purchase shares in the target company to capitalize on the anticipated price increase. Option C. Discuss the potential takeover with colleagues in other departments at TechnoPro Holdings to gauge their opinions on the strategic implications. Option D. Refrain from trading in the target company's securities and avoid disclosing the information to any unauthorized parties. The correct answer is B. Immediately purchase shares in the target company to capitalize on the anticipated price increase. Explanation. This scenario presents a professional challenge for a TechnoPro Holdings employee due to the inherent conflict between client confidentiality and the potential for insider trading. The employee has received material, non-public information about a significant upcoming acquisition that could substantially impact the share price of the target company. The challenge lies in navigating the ethical and regulatory landscape to avoid both breaching confidentiality obligations to TechnoPro Holdings' client and engaging in illegal insider trading. Careful judgment is required to distinguish between permissible actions and those that could lead to severe legal and professional repercussions. The correct approach involves strictly adhering to TechnoPro Holdings' internal policies and relevant regulatory guidelines regarding the handling of material non-public information. This means refraining from trading in the securities of the target company or any related entities, and also avoiding any disclosure of this information to unauthorized individuals, including friends or family, regardless of their investment intentions. This approach is ethically sound and legally compliant, as it upholds the principles of market integrity and protects TechnoPro Holdings from regulatory scrutiny and reputational damage. It directly aligns with the spirit and letter of insider trading regulations, which aim to ensure a level playing field for all investors. An incorrect approach would be to trade in the securities of the target company based on the acquired information. This constitutes illegal insider trading, as it exploits privileged information for personal gain, thereby undermining market fairness. Another incorrect approach would be to disclose the information to a friend or family member who then trades on it. While the employee themselves might not directly profit, they would be facilitating insider trading and potentially be held liable as an aider and abettor, violating both regulatory prohibitions and ethical duties of confidentiality. A third incorrect approach would be to discuss the information generally with colleagues at TechnoPro Holdings who are not directly involved in the transaction, as this could inadvertently lead to wider dissemination and increase the risk of leaks, even if no immediate trades are made. Professionals facing similar situations should employ a decision-making framework that prioritizes regulatory compliance and ethical conduct. This involves 1. Identifying the nature of the information received. Is it material and non-public? 2. Understanding the potential impact of the information on securities prices. 3. Consulting internal compliance policies and relevant regulations to determine permissible actions. 4. Seeking guidance from the compliance department or legal counsel if there is any ambiguity. 5. Prioritizing the preservation of confidentiality and market integrity above any potential personal or third-party financial benefit. Question 11. Which approach would be most appropriate for a TechnoPro Holdings employee who has inadvertently accessed confidential, non-public information about an upcoming significant corporate event that could substantially impact the company's stock price? Option A. Discreetly use the information to make a personal investment in the company's stock before the event is publicly announced. Option B. Continue with normal work duties, disregarding the information as it was accessed accidentally and not actively sought. Option C. Immediately cease any further engagement with the information and report it through TechnoPro Holdings' designated internal compliance channels. Option D. Share the information with a close friend who is an experienced investor, suggesting they consider investing. The correct answer is C. Immediately cease any further engagement with the information and report it through TechnoPro Holdings' designated internal compliance channels. Explanation. Scenario analysis. This scenario presents a professional challenge for TechnoPro Holdings employee due to the inherent conflict between client confidentiality and the potential for market abuse. The employee has obtained sensitive, non-public information that, if acted upon, could lead to significant personal gain, but also constitutes insider trading, a serious regulatory offense. The challenge lies in navigating this ethical tightrope, balancing professional duties with personal temptation, and understanding the severe consequences of misjudgment. The need for discretion and adherence to strict regulatory frameworks is paramount. Correct approach analysis. The correct approach involves immediately ceasing any further consideration of using the information for personal benefit and reporting the situation through the appropriate internal channels at TechnoPro Holdings, such as the compliance department or a designated supervisor. This aligns with the regulatory framework governing financial markets, which strictly prohibits the use of inside information for trading. Specifically, under the UK's Financial Services and Markets Act 2000 FSMA and the Market Abuse Regulation MAR, possessing and acting on inside information is illegal and carries severe penalties, including fines and imprisonment. Ethically, TechnoPro Holdings has a duty to its clients and the integrity of the market to prevent such abuses. Reporting the information internally ensures that the company can take appropriate steps to safeguard the information and prevent any potential market abuse, thereby upholding its regulatory obligations and professional integrity. Incorrect approaches analysis. Acting on the information by trading securities before it becomes public would be a direct violation of insider trading regulations, such as those outlined in FSMA and MAR. This constitutes a severe ethical and legal failure, demonstrating a disregard for professional conduct and market integrity. It would expose both the individual and potentially TechnoPro Holdings to significant legal repercussions. Sharing the information with a trusted friend or family member who could then trade on it, even if the employee themselves does not trade, is also a form of insider dealing. This is because the employee is facilitating the abuse of inside information. This action would still fall under the purview of MAR and FSMA, as it involves the unlawful disclosure of inside information and the subsequent trading based on that information. It represents a breach of confidentiality and a failure to uphold regulatory standards. Ignoring the information and continuing with normal duties without reporting it, while seemingly neutral, is also an incorrect approach. This passive inaction allows the potential for abuse to persist. If the information were to be discovered later and it was known that the employee was aware of it and did not report it, they could still be held accountable for failing to take reasonable steps to prevent market abuse, which is a breach of their professional duty and regulatory expectations. Professional reasoning. Professionals in the financial services industry, particularly those working for firms like TechnoPro Holdings, must adopt a proactive and principled approach when encountering potentially sensitive or non-public information. The decision-making process should prioritize adherence to the regulatory framework and ethical conduct. This involves 1. recognizing the nature of the information and its potential implications. 2. Understanding the relevant laws and regulations, e.g., UK's FSMA and MAR. 3. Consulting internal policies and compliance procedures. 4. Seeking guidance from the compliance department or legal counsel if unsure. 5. Acting with integrity and transparency, even when faced with personal temptation or difficult circumstances. The overarching principle is to protect the integrity of the financial markets and uphold the trust placed in them by clients and the public. Question 12. Implementation of a new client onboarding process at TechnoPro Holdings has led to the discovery of potentially misleading information provided by a prospective corporate client regarding their source of funds. The information appears to be inconsistent with publicly available data and raises concerns about potential money laundering activities. An employee has received this information and is unsure how to proceed, given the dual obligations of client due diligence and regulatory reporting. Option A. Advise the prospective client that their information is insufficient and decline to proceed with onboarding without further internal consultation. Option B. Immediately report the concerns and the client's information to the relevant financial intelligence unit, bypassing internal reporting channels. Option C. Document the concerns and the information received and confidentially report it to TechnoPro Holdings, designated compliance officer, for internal review and appropriate action. Option D. Conduct an independent, informal investigation into the client's financial activities to verify the information before deciding on any action. The correct answer is B. Immediately report the concerns and the client's information to the relevant financial intelligence unit, bypassing internal reporting channels. Explanation. This scenario presents a professional challenge for TechnoPro Holdings employees due to the inherent conflict between client confidentiality and the need to report potential regulatory breaches. Navigating this requires a deep understanding of the regulatory framework governing financial services in the specified jurisdiction, which mandates strict adherence to client privacy while simultaneously imposing obligations to report suspicious activities. The core of the challenge lies in balancing these competing duties without compromising either. The correct approach involves a meticulous, fact-based assessment of the information received, followed by a confidential internal reporting mechanism to the designated compliance officer or legal department within TechnoPro Holdings. This ensures that the information is handled appropriately, investigated thoroughly, and reported to the relevant authorities if necessary, all while maintaining the highest standards of client confidentiality and adhering to regulatory reporting obligations. This aligns with the principles of professional conduct and regulatory compliance, which prioritize integrity and the prevention of financial crime. An incorrect approach would be to directly disclose the client's information to external parties without proper authorization or a clear regulatory mandate to do so. This would violate client confidentiality, potentially leading to legal repercussions and reputational damage for both the employee and TechnoPro Holdings. Another incorrect approach would be to ignore the information or fail to report it internally, which would be a dereliction of duty and a breach of regulatory requirements to report suspicious activities, exposing TechnoPro Holdings to significant penalties. Finally, attempting to investigate the matter independently without involving the compliance department could lead to an incomplete or biased assessment, and could also inadvertently breach confidentiality or interfere with official investigations. Professionals facing such situations should employ a structured decision-making process. First, identify the core issue and potential regulatory implications. Second, consult internal policies and procedures regarding client confidentiality and suspicious activity reporting. Third, seek guidance from the compliance or legal department. And fourth, act strictly in accordance with established protocols and regulatory mandates. This systematic approach ensures that all relevant obligations are considered and met. Question 13. Compliance review shows that a client of TechnoPro Holdings has requested a specific, high-risk, illiquid investment product that they believe will generate rapid returns. The client has provided limited information about their overall financial situation and risk tolerance. TechnoPro Holdings' internal policy requires a comprehensive suitability assessment before recommending any investment. What is the most appropriate course of action for the TechnoPro Holdings advisor? Option A. Decline to offer the requested investment and inform the client that TechnoPro Holdings does not deal in such products without further discussion. Option B. Proceed with the client's requested investment after obtaining a signed disclaimer acknowledging the risks, as the client has explicitly requested it. Option C. Conduct a thorough suitability assessment, including understanding the client's financial situation, investment objectives, and risk tolerance, and then recommend suitable products, explaining why they are appropriate and addressing the client's initial request. Option D. Recommend a different, less risky investment that TechnoPro Holdings has a strong relationship with, without fully exploring the client's original request or conducting a detailed suitability assessment for that specific request. The correct answer is B. Proceed with the client's requested investment after obtaining a signed disclaimer acknowledging the risks, as the client has explicitly requested it. Explanation. This scenario presents a professional challenge due to the inherent conflict between a client's desire for a specific investment outcome and the firm's regulatory obligations to act in the client's best interest and provide suitable advice. TechnoPro Holdings must navigate the complexities of client expectations while adhering strictly to the regulatory framework governing financial advice. The core of the challenge lies in ensuring that any recommendation is not only aligned with the client's stated goals, but also demonstrably suitable given their financial situation, risk tolerance, and investment objectives, as mandated by regulatory principles. The correct approach involves a thorough and documented assessment of the client's financial circumstances, risk profile, and investment objectives. This assessment must then be used to identify and recommend products or strategies that are genuinely suitable for the client, even if they differ from the client's initial, potentially ill-informed, request. This aligns with the regulatory requirement to act in the client's best interest, which prioritizes suitability over simply fulfilling a client's expressed wish if that wish is not in their best interest. Ethical considerations also demand transparency and a fiduciary duty to the client, ensuring they understand the rationale behind the advice provided. An incorrect approach would be to proceed with the client's requested investment without adequate due diligence. This fails to uphold the regulatory obligation to assess suitability and act in the client's best interest. It risks exposing the client to undue risk or suboptimal returns, potentially leading to regulatory sanctions and reputational damage for TechnoPro Holdings. Another incorrect approach would be to dismiss the client's request outright without attempting to understand the underlying motivation, or to educate the client on more suitable alternatives. This demonstrates a lack of client engagement and could be perceived as poor service, even if technically compliant with suitability rules. A third incorrect approach might involve subtly steering the client towards a product that benefits the firm more, even if it's only marginally less suitable than another option, as this compromises the duty of care and could be seen as a conflict of interest. Professionals should employ a structured decision-making process that begins with a comprehensive understanding of the client's needs and objectives, followed by a rigorous evaluation of available investment options against regulatory suitability criteria. If a client's request conflicts with these criteria, the professional must clearly communicate the reasons for this discrepancy, explain the risks and benefits of alternative suitable options, and document the entire process, including the client's final decision and the rationale behind it. Question 14. During the evaluation of a new client's investment portfolio at TechnoPro Holdings, a prospective client expresses a strong desire to invest a significant portion of their funds in a highly speculative, unproven technology stock that has recently experienced a surge in price. The client states that they are aware of the risks, but are confident in the company's potential for rapid growth and are willing to accept the potential for substantial losses. As a TechnoPro Holdings advisor, what is the most appropriate course of action according to the regulatory framework? Option A. Conduct a comprehensive suitability assessment to determine if the speculative stock aligns with the client's overall financial objectives, risk tolerance and financial situation, and present alternative, more diversified investment options if necessary. Option B. Advise the client that TechnoPro Holdings does not permit investments in highly speculative stocks and suggest a more conservative investment strategy. Option C. Investigate the speculative stock further to identify any immediate red flags or regulatory concerns before advising the client, without conducting a full suitability assessment at this stage. Option D. Proceed with the investment as requested by the client, emphasizing the potential for high returns and acknowledging the client's stated risk tolerance. Correct answer is D. Proceed with the investment as requested by the client, emphasizing the potential for high returns and acknowledging the client's stated risk tolerance. Explanation. This scenario presents a professional challenge due to the inherent conflict between a client's immediate desire for a specific investment outcome and the advisor's fiduciary duty to act in the client's best interest. Considering all relevant regulatory obligations, the advisor must navigate potential conflicts of interest and ensure that recommendations are suitable and compliant, even if they deviate from the client's initial, potentially ill-informed preference. This requires a deep understanding of the regulatory framework governing financial advice. The correct approach involves a thorough suitability assessment that prioritizes the client's financial objectives, risk tolerance, and overall financial situation, as mandated by the relevant regulatory framework. This includes providing comprehensive information about alternative investments that may better align with the client's long-term interests, even if they are less appealing in the short term. The advisor must document this process meticulously, demonstrating that the recommendation was made in the client's best interest and in compliance with all applicable regulations. An incorrect approach that solely focuses on fulfilling the client's stated preference without a comprehensive suitability assessment would be a failure to uphold the advisor's fiduciary duty. This could lead to recommendations that are not in the client's best financial interest, potentially exposing the client to undue risk or suboptimal returns, and violating regulatory requirements for client protection. Another incorrect approach that involves pressuring the client to accept a recommendation that the advisor believes is not suitable, or misrepresenting the risks and rewards of an investment to align with the client's initial request, constitutes a serious ethical and regulatory breach. This undermines client trust and violates principles of transparency and fair dealing. Professionals should employ a decision-making framework that begins with a clear understanding of the client's stated needs and objectives. This is followed by a rigorous assessment of suitability based on the client's financial profile and the characteristics of potential investments. The advisor must then present a range of suitable options, clearly explaining the risks, rewards, and costs associated with each, and provide a reasoned recommendation. Throughout this process, adherence to the regulatory framework and ethical principles of acting in the client's best interest, transparency, and integrity is paramount. Documentation of all advice and client interactions is crucial for demonstrating compliance. Question 15. Risk assessment procedures indicate that a senior analyst at TechnoPro Holdings has discovered a pattern of transactions by a key client that, while not definitively illegal, appear to circumvent certain reporting thresholds designed to detect market manipulation. The analyst is concerned about the potential implications for TechnoPro Holdings' compliance obligations and its reputation. What is the most appropriate course of action for the analyst to take? Option A. Advise the client to alter their transaction patterns to avoid any appearance of impropriety without reporting the issue internally. Option B. Discuss the observed transaction patterns with the client directly to understand their intentions and seek clarification. Option C. Document the observed transaction patterns and report them through TechnoPro Holdings' internal compliance reporting channels for investigation. Option D. Immediately report the suspected circumvention of reporting thresholds to the relevant regulatory authority. The correct answer is D. Immediately report the suspected circumvention of reporting thresholds to the relevant regulatory authority. Explanation. This scenario presents a professional challenge for TechnoPro Holdings employees due to the inherent conflict between client confidentiality and the need to report potential regulatory breaches. The firm's commitment to its clients' privacy is paramount, but this must be balanced against its legal and ethical obligations to uphold regulatory integrity. Careful judgment is required to navigate this delicate balance, ensuring that TechnoPro Holdings acts responsibly without unnecessarily compromising client trust or violating data protection principles. The correct approach involves a multi-step process that prioritizes internal reporting and escalation within TechnoPro Holdings, adhering strictly to established internal policies and relevant regulatory guidelines for handling suspected breaches. This approach ensures that the matter is investigated by authorized personnel who understand the firm's obligations and the applicable regulatory framework. It respects client confidentiality by avoiding direct, unauthorized disclosure, and instead channels the information through appropriate internal channels for assessment and potential reporting to the relevant authorities, as mandated by law and ethical codes. This aligns with the principles of responsible corporate conduct and regulatory compliance. An incorrect approach of directly reporting the suspected breach to the regulatory authority without internal consultation or investigation would be professionally unacceptable. This failure stems from a disregard for internal reporting protocols, which are designed to ensure accuracy, completeness, and adherence to legal disclosure requirements. It also risks violating client confidentiality and potentially misinterpreting the situation, leading to unwarranted regulatory scrutiny for the client and TechnoPro Holdings. Another incorrect approach, that of ignoring the potential breach due to the client's importance or the perceived low risk, represents a significant ethical and regulatory failure. This demonstrates a lack of due diligence and a failure to uphold the firm's responsibility to maintain market integrity. It could expose TechnoPro Holdings to severe penalties for noncompliance and damage its reputation. A further incorrect approach, which is to discuss the suspected breach with colleagues outside of the designated internal reporting structure, also constitutes a serious breach of confidentiality and professional conduct. This unauthorized disclosure can lead to the spread of sensitive information, potential market manipulation, and a breakdown of trust within the firm and with its clients. The professional decision-making process for similar situations should involve 1. Recognizing the potential issue and its implications. 2. Consulting internal policies and procedures for handling suspected regulatory breaches. 3. Reporting the concern through the designated internal channels to the appropriate compliance or legal department. 4. Cooperating fully with the internal investigation. 5. Following the guidance provided by the internal experts regarding any necessary external reporting, ensuring it is done in accordance with all applicable laws and regulations. Question 16. Performance analysis shows that a TechnoPro Holdings project team has inadvertently uncovered information regarding a significant upcoming product recall that is not yet public. Two team members are discussing the potential impact on the company's stock price, with one suggesting they should inform their immediate supervisor who is not part of the project. Which of the following represents the most appropriate and compliant course of action for the TechnoPro Holdings employees involved? Option A. Immediately cease all discussion of the information and report the situation to the TechnoPro Holdings Compliance Department. Option B. Share the information with a trusted colleague outside the project team to get their opinion on its materiality. Option C. Continue the discussion to clarify the full scope of the recall and its potential impact before informing anyone. Option D. Proceed with informing their supervisor, as they are a senior member of the company and may need to know. The correct answer is A. Immediately cease all discussion of the information and report the situation to the TechnoPro Holdings Compliance Department. Explanation. Scenario analysis. This scenario presents a professional challenge for TechnoPro Holdings employees regarding the appropriate handling of potentially material non-public information, MNPI. The challenge lies in balancing the need to share information for legitimate business purposes with the strict regulatory prohibition against insider trading. Employees must exercise sound judgment to identify when information crosses the threshold into MNPI and to ensure that any dissemination adheres to strict compliance protocols. Failure to do so can result in severe regulatory penalties, reputational damage, and loss of trust. Correct approach analysis. The correct approach involves immediately ceasing any discussion of the sensitive information and reporting the situation to the compliance department. This is the most professional and legally sound course of action because it prioritizes regulatory compliance and risk mitigation. TechnoPro Holdings, like any regulated entity, is bound by laws and guidelines that prohibit the misuse of MNPI. By reporting to compliance, employees ensure that the company can take appropriate steps to manage the information, such as issuing a cautionary notice or restricting trading by individuals who may have had access. This aligns with the principles of fair markets and investor protection, which are fundamental to financial regulation. Incorrect approaches analysis. Proceeding with the discussion to clarify the information before reporting is incorrect because it risks further dissemination of MNPI without proper authorization or control. This action could be interpreted as an attempt to tip others or to use the information for personal gain, directly violating insider trading regulations. Sharing the information with a trusted colleague outside of the immediate project team, even with the intention of seeking advice, is also incorrect. This expands the circle of individuals exposed to MNPI without a clear business need or compliance oversight, increasing the risk of accidental disclosure or misuse. It bypasses the established reporting channels designed to manage such sensitive information. Assuming the information is not material enough to warrant reporting is a dangerous assumption. The determination of materiality is complex and often subjective, and it is the responsibility of the compliance department, not individual employees, to make this assessment. Acting on such an assumption can lead to inadvertent violations of regulations. Professional reasoning. Professionals at TechnoPro Holdings should adopt a when in doubt report mindset. The decision-making process should involve 1. Recognizing the potential for information to be MNPI. 2. Understanding the severe consequences of misuse. 3. Immediately halting any further discussion or dissemination. 4. Promptly reporting the situation to the designated compliance or legal department. 5. Following the guidance provided by the compliance department without deviation. This structured approach ensures that regulatory obligations are met and that the company's integrity is maintained. Question 17. Quality control measures reveal a discrepancy in the reconciliation of client segregated funds at TechnoPro Holdings. A specific client's account shows a shortfall of £5,000, which appears to have occurred over the past week due to a series of complex trades. The junior operations team member who identified the issue is concerned about the potential impact on client assets and regulatory reporting. What is the most appropriate immediate course of action for the junior operations team member to take? Option A. Immediately escalate the discrepancy to the head of compliance and the chief operations officer, providing all available transaction details, and await further instructions while ensuring no further transactions are processed on the affected client account until the issue is resolved. Option B. Inform the affected client directly about the potential shortfall and ask them to provide details of their recent trades to help identify the source of the error. Option C. Continue with the daily reconciliation process as usual, assuming the discrepancy will correct itself in subsequent reconciliations, and only report it if it persists for more than 2 weeks. Option D. Attempt to resolve the discrepancy by manually adjusting the client's account balance to reflect the expected amount, assuming it was a minor clerical error, and document the adjustment internally. The correct answer is A. Immediately escalate the discrepancy to the head of compliance and the chief operations officer, providing all available transaction details, and await further instructions while ensuring no further transactions are processed on the affected client account until the issue is resolved. Explanation. This scenario presents a professional challenge because TechnoPro Holdings, as a regulated entity, must ensure its internal processes align with the stringent requirements of the Financial Conduct Authority (FCA) handbook, specifically regarding client asset protection and record keeping. The challenge lies in balancing operational efficiency with the absolute necessity of safeguarding client funds and maintaining auditable trails, which are fundamental to maintaining client trust and regulatory compliance. A failure in these areas can lead to significant reputational damage, regulatory sanctions, and financial penalties. The correct approach involves immediate escalation and thorough investigation, prioritizing client asset segregation and reconciliation. This aligns with the FCA's principles for businesses, particularly Principle 10, Clients' Interests, and Principle 11, Communications with Clients, Regulators, and Others, and specific rules within the Client Asset CAS sourcebook. CAS 6 mandates the segregation of client money, and CAS 7 details the procedures for holding and handling client money. Promptly identifying the discrepancy, halting further transactions that could exacerbate the issue, and initiating a detailed reconciliation process are crucial steps to mitigate risk and demonstrate due diligence to the regulator. This proactive stance is essential for demonstrating a commitment to client protection and regulatory adherence. An incorrect approach that involves attempting to resolve the discrepancy internally without immediate escalation or proper documentation risks violating CAS rules. If the discrepancy is not immediately addressed and the client's assets are not properly segregated or accounted for, it could be construed as a breach of client asset rules, potentially leading to a shortfall. Another incorrect approach, such as delaying the investigation or attempting to obscure the issue, would be a severe breach of Principle 11, which requires firms to be open and cooperative with the FCA. Furthermore, failing to maintain accurate and complete records, as required by SISC, senior management arrangements, systems and controls, and other FCA rules, would undermine any subsequent investigation and demonstrate a systemic failure in internal controls. Professionals should employ a decision-making framework that prioritizes regulatory compliance and client interests. This involves 1. Recognizing and understanding the potential regulatory implications of any operational issue. 2. Immediately escalating any identified discrepancies or potential breaches to the appropriate internal compliance and risk management functions. 3. Following established internal procedures for investigation and remediation, ensuring all actions are documented. 4. Maintaining open and transparent communication with the regulator as required. 5. Continuously reviewing and improving internal controls to prevent recurrence. Question 18. Process analysis reveals that TechnoPro Holdings is undertaking a new strategic initiative requiring a comprehensive review of client risk profiles. To effectively assess potential risks associated with this initiative, the Compliance Department needs to understand general patterns and trends in client transaction data. However, direct access to individual client transaction details is restricted by strict confidentiality agreements and data privacy regulations. TechnoPro Holdings must find a way to gather the necessary insights for risk assessment without compromising client confidentiality or violating regulatory mandates. Which of the following approaches best addresses this challenge for TechnoPro Holdings? Option A. Directly access and review individual client transaction records to build a detailed understanding of client behavior, assuming that internal risk assessment justifies such access. Option B. Request that clients voluntarily submit summaries of their transaction history that they deem relevant to the risk assessment. Option C. Implement a robust internal process for anonymizing and aggregating client transaction data to identify broad risk patterns, while seeking explicit client consent for any limited, necessary access to non-anonymized data for specific high-risk cases, all documented under a clear internal policy. Option D. Rely solely on publicly available market data and general industry risk reports to inform the strategic initiative, without any internal review of client-specific data. The correct answer is C. Implement a robust internal process for anonymizing and aggregating client transaction data to identify broad risk patterns, while seeking explicit client consent for any limited, necessary access to non-anonymized data for specific high-risk cases, all documented under a clear internal policy. Explanation. This scenario presents a professional challenge for TechnoPro Holdings due to the inherent conflict between client confidentiality and the need for internal risk assessment. The company must navigate the delicate balance of obtaining necessary information for due diligence without breaching client trust or violating regulatory obligations. Careful judgment is required to ensure that any information gathering is conducted ethically and in compliance with applicable regulations. The correct approach involves a structured and authorized internal review process that prioritizes data minimization and anonymization where possible, while still allowing for a thorough risk assessment. This approach is right because it upholds the principles of client confidentiality and data privacy, which are paramount in the financial services industry. Specifically, it aligns with the regulatory framework for data protection and client due diligence, ensuring that TechnoPro Holdings acts responsibly and maintains the trust of its clients. By seeking explicit consent or utilizing anonymized data, the company demonstrates a commitment to ethical conduct and regulatory compliance. An incorrect approach that involves directly accessing and reviewing client transaction details without explicit consent or a clear, documented internal policy for such access would be professionally unacceptable. This failure stems from a breach of client confidentiality and potentially violates data protection regulations, which mandate that personal and sensitive client information is handled with the utmost care and only for legitimate authorized purposes. Another incorrect approach, such as relying solely on external, unverified information without any internal due diligence, be professionally unacceptable because it fails to meet the company's responsibility to conduct thorough risk assessments and could expose TechnoPro Holdings to significant compliance and reputational risks. Professionals should employ a decision-making framework that begins with identifying the core ethical and regulatory obligations. This involves understanding the specific requirements of client confidentiality, data privacy laws, and internal company policies. The next step is to assess the information needed for the task at hand and explore the least intrusive methods for obtaining it. This often includes considering anonymization, aggregation, or seeking explicit client consent. If direct access to sensitive information is unavoidable, it must be done under strict, documented protocols that limit access and ensure data security. Finally, all actions must be reviewed against regulatory guidelines and ethical best practices to ensure compliance and maintain professional integrity. Question 19. The evaluation methodology shows that a TechnoPro Holdings analyst, while reviewing a client's portfolio, discovers a pattern of trades that appear to be designed to manipulate a specific stock's price. The analyst is concerned that these trades may violate market abuse regulations. What is the most appropriate course of action for the analyst to take? Option A. Ignore the trading pattern. Assuming it is a legitimate trading strategy the analyst does not fully understand. Option B. Directly confront the client about the suspected market manipulation and ask for an explanation. Option C. Immediately report the suspicious trading activity to the relevant regulatory authority. Option D. Document the findings and escalate the concerns internally to TechnoPro Holdings Compliance Department. The correct answer is C. Immediately report the suspicious trading activity to the relevant regulatory authority. Explanation. This scenario presents a professional challenge for TechnoPro Holdings employees due to the inherent conflict between client confidentiality and the need to report potential regulatory breaches. The core difficulty lies in balancing the duty of discretion owed to clients with the overarching obligation to uphold the integrity of financial markets and comply with regulatory directives. Careful judgment is required to navigate this delicate balance without jeopardizing client relationships or exposing the firm to regulatory sanctions. The correct approach involves discreetly escalating the concerns internally through established compliance channels, rather than directly confronting the client or ignoring the issue. This method is professionally sound because it adheres to TechnoPro Holdings' internal policies and, crucially, aligns with the regulatory framework that mandates reporting of suspicious activities. By reporting internally, the employee initiates a formal review process that allows the compliance department to assess the situation objectively, gather further information if necessary, and make an informed decision on whether external reporting to the relevant regulatory body is required. This process protects the employee from direct liability, ensures the firm acts responsibly, and upholds regulatory integrity. An incorrect approach would be to directly confront the client about the suspected breach. This is professionally unacceptable as it could prejudice any subsequent investigation, potentially alert the client to the fact that their activities are under scrutiny, and may lead to the destruction of evidence. Furthermore, it bypasses the firm's internal controls and compliance procedures, which are designed to manage such situations effectively and in accordance with regulatory requirements. Another incorrect approach is to ignore the suspicious activity. This is a severe ethical and regulatory failure. It demonstrates a lack of diligence and a disregard for the firm's obligations to prevent financial crime and market abuse. By failing to act, the employee in TechnoPro Holdings could be seen as complicit, leading to significant penalties, reputational damage, and loss of trust from regulators and the public. Professionals should employ a decision-making framework that prioritizes adherence to internal policies and regulatory mandates. This involves recognizing potential red flags, understanding the firm's reporting obligations, and utilizing established internal escalation procedures. When in doubt, seeking guidance from the compliance department or legal counsel is paramount. This systematic approach ensures that all actions are taken within the bounds of the law and ethical conduct, safeguarding both the individual and the organization. Question 20. The monitoring system demonstrates an unusual pattern of transactions involving client funds that could potentially impact the segregation of client assets. TechnoPro Holdings Head of Operations, MS, Anya Sharma, reviews the alert and notes a deviation from standard operating procedures. What is the most appropriate immediate course of action for MS, Sharma to take? Option A. Escalate the flagged activity and all associated data to the compliance department for immediate review and investigation. Option B. Document the flagged transaction internally and schedule a review with the IT department to investigate the monitoring system's accuracy. Option C. Inform the affected clients directly about the potential issue and seek their guidance on how to proceed. Option D. Immediately initiate a manual transfer of the affected client funds to a designated segregated account to rectify the situation. The correct answer is D. Immediately initiate a manual transfer of the affected client funds to a designated segregated account to rectify the situation. Explanation. This scenario presents a professional challenge because TechnoPro Holdings' internal monitoring system has flagged a potential breach of regulatory compliance related to client asset segregation. The challenge lies in interpreting the flagged activity, understanding the precise regulatory requirements for asset segregation under the specified jurisdiction, which for this exam is assumed to be the UK Financial Conduct Authority (FCA) handbook, and determining the appropriate immediate and subsequent actions. Misinterpreting the data or failing to act decisively could lead to significant regulatory penalties, reputational damage, and harm to clients. Careful judgment is required to balance the need for swift action with the importance of accurate assessment and adherence to established procedures. The correct approach involves immediately escalating the flagged activity to the compliance department for a thorough investigation. This is the most professionally sound action because it ensures that the potential breach is reviewed by individuals with specialized knowledge of regulatory requirements and internal policies. The FCA handbook, specifically in areas like CAS, client money and assets, mandates strict rules for the segregation and protection of client assets. Prompt escalation allows for a formal investigation to determine if a breach has occurred, its severity, and the necessary remedial actions, which may include reporting to the FCA. This aligns with the ethical duty to act with integrity and due diligence in protecting client interests and upholding regulatory standards. An incorrect approach would be to dismiss the alert without further investigation, assuming it is a false positive. This fails to acknowledge the potential seriousness of a client asset segregation issue and directly contravenes the regulatory expectation that firms have robust systems in place to detect and address such breaches. Ethically, it demonstrates a lack of diligence and a disregard for client protection. Another incorrect approach would be to attempt to rectify the situation internally without involving compliance, perhaps by attempting to move assets without proper authorization or documentation. This bypasses established procedures designed to ensure regulatory adherence and could inadvertently create further compliance issues or even be construed as an attempt to conceal a breach. It undermines the integrity of internal controls and the regulatory reporting framework. Finally, an incorrect approach would be to delay reporting the issue to compliance while gathering more information independently. While information gathering is important, undue delay in escalating a potential client asset segregation issue can be interpreted as a failure to act promptly, which is a critical regulatory expectation. The primary professional reasoning framework in such situations involves a risk-based approach. Identify potential risks, assess their severity, and implement controls or escalate as appropriate. When client assets are involved, the default action for any flagged anomaly should be prompt escalation to the designated compliance function.